I witnessed, recorded, and produced these videotapes of the Washington, D.C. hearing. Their authenticity is above question.
This is produced as part of the ongoing work on the website, thewaythetruthandthelife.net.
This is a hearing about the government licensing the electrocution of people to cause grand mal seizures. Think of the millions of dollars, taxpayers' money, spent to pay psychiatrists and their supporters and for the worldwide travel in putting this conference together, while the victims and opponents had to pay their own way.
The next speaker this morning will be John Parry, who will be speaking on issues of informed consent. Parry.
In this presentation, I will review three essential aspects of the law of ECT: decision-making rights of mentally disabled persons, the principles of informed consent, and the law of substitute consent for mentally incompetent persons. Then I will apply these parts of the law to ECT specifically. Much of my research is derived from two of the chapters I prepared for the third edition of the American Bar Foundation's The Mentally Disabled in the Law, which is scheduled to be published at the end of this summer. The other authors are Samuel Brackholt and Barbara Weiner. In addition, I've written an article which will appear in the May-June issue of the Mental and Physical Disability Law Reporter at the end of June. This article will be an expansion and in a few instances a revision of the abstract that I completed for this panel in April. The overriding thesis that I wish to present to you today is the value, perhaps the necessity, of using the existing law in formulating a consensus concerning the regulation of ECT. It is my view that the parameters of the law, including the federal and state constitutions, state statutes, and common law, provide a reasonable framework upon which to develop sound policy judgments about the right of mental patients to accept or refuse ECT. The starting point for my presentation is the decision-making rights of all mentally disabled persons. A broad overview of the modern law indicates clearly that while consistency and fairness could be improved substantially if the law was applied with finer discriminations using standards which address more precisely the actual abilities and disabilities of each mentally disabled citizen, the law does recognize a right of self-determination expressed by mental patients or their authorized substitute decision makers. Moreover, the free expression of the right usually takes legal precedence over the patient's medical best interest alone. Serious problems persist in the way society and society's agents treat mentally disabled persons. While the institutional snake pits are more rare, experts that appeared before the Senate Committee on the Handicapped earlier this year confirmed what others have observed. Mentally disabled persons, particularly those in institutions, are all too frequently victims of discrimination, neglect, and abuse. In general, mentally disabled persons remain the subjects of over-inclusive limits on their decision-making rights based on labels and categorizations that tend to ignore or exclude individualized assessments of their actual abilities and disabilities. Examples of this phenomenon can be seen in restrictions on voting and driving, the overuse of plenary guardianship, and the bureaucratic tendency to overly rely on institutional care. Indeed, this misperception about the abilities and disabilities of individuals is pervasive. Unfortunately, as a result of both sincere paternalism and professional self-interest, the medical and social service models often reinforce this bias towards over-inclusive categorizing. At the other end of the spectrum, the legal advocacy model of patient representation sometimes tends towards under-inclusive categorizing based on an equally sincere belief in the principle of self-determination for all and not the similar professional interests of its own. At times, individuals who clearly would benefit from care and treatment are allowed to follow the counsel of their own mind, even in circumstances in which caregivers but not the legal system, are convinced that patients are incompetent to decide for themselves. What is difficult for many caregivers to accept is that the legal advocacy model, when it allows the patient or is authorized as representative to make a choice, which may go against the patient's medical interest, is consistent with traditional American beliefs and thus reflective of the laws that have been applied in society. In general, modern legal theory presumes that every person, mentally disabled or not, is capable of functioning normally with regard to exercising any right or privilege unless facts can be marshaled in a court of law to demonstrate that specific incapacities exist. In the medical context, the law supports the view that unless a person has been adjudicated incompetent or a legitimate emergency can be demonstrated after the fact, the principle of self-determination will win out over the best interest of the individual as reflected by community or medical standards. This, I believe, is as it should be. The second aspect of my presentation regarding the regulation of ECT are the elements of voluntary, knowing, and competent consent that comprise the concept of informed consent. It is important to recognize before major changes are recommended and implemented in existing laws of informed consent that relatively few empirical studies have evaluated the elements of informed consent. As you will hear shortly from one of the authors of the most comprehensive study to date, relatively little is known about the adequacy of information needed for mentally disabled persons to make informed medical choices. Moreover, even Lauren Roth's study was relatively narrow in scope and indicates more studies are needed. Threat of force, coercion, fraud, duress, deceit, and other kinds of overreaching jeopardize voluntariness, the first element of informed consent. Whether any particular action is taken by hospital staff or conditions within an institution by themselves or in combination with other factors constitute sufficient negative influence on the patient to legally invalidate consent is a matter of fact that is determined by a judge or jury. It seems self-evident that in a hospital or other kind of institution in which patients or residents are isolated and vulnerable, it is unwise to assume the patient decisions are voluntary. While instances of physical abuse, coercion, and fraud appear to be less frequent in a modern mental hospital, such abuses are not yet uncommon, and other kinds of overreaching, including deceit, duress, and threat of force, are still documented as occurring regularly. Knowledge, the second and quintessential element of informed consent, is right before any treatment may be administered. It is defined differently depending on the jurisdiction. The community standard or old rule was set out in Nathanson versus Klein. In that decision, the kind and quality of information a doctor is obliged to communicate to a patient is defined as that information which would be conveyed by typical medical practitioners, either in their specialty area of medicine or in the geographical area in which they reside. In essence, the standard emphasizes what other doctors would do in similar circumstances. The so-called reasonable patient standard, or modern rule, emphasizes the right of patients to make their own determinations about medical treatment by providing them with sufficient information to understand the risks and benefits of a given medical procedure and to identify and evaluate the available alternatives. In this standard, quality of information is critical. Today, both standards are used, as well as schemes in various jurisdictions that mix elements of each standard. In a few states, entirely new approaches have been enacted, such as the use of medical review boards in Texas and Hawaii. Nevertheless, there are exceptions that modify all such schemes. First and foremost is the existence of a medical emergency, defined narrowly by the presence of two basic conditions. One, patients must be so incapacitated they are incompetent to exercise their decision-making rights. And two, there must be a life-threatening disease or injury that requires immediate treatment. In certain jurisdictions, emergency also includes any condition that would substantially threaten the health of the patient, even if death were not a likely result. A second major defense is therapeutic privilege. As defined in the case law and statutes, the privilege exists when the total disclosure of information to patients will have a significant negative effect on the patient's condition. In these limited situations, a physician looking at the circumstances from the patient's point of view may take reasonable steps to communicate or withhold information consistent with the patient's welfare. In addition, there are a variety of problems for the plaintiff to overcome or defenses for the doctor, which makes liability relatively infrequent. The final element is competent consent. The concept varies significantly among jurisdictions and often has little to do with clinical notions of competency. In the most precise formulations, which I favor, competency determinations are limited to specific decision-making questions that is factually at issue, such as the ability to accept or refuse psychiatry. However, remnants of the broader formulations linger on. Although almost no state still equates civil commitment with incompetency, the American Psychiatric Association's model civil commitment statute, California, and Utah include medical decision-making and commitment at the expense of giving greater weight to the patient's right of self-determination. It's obvious that in order to be most accurate, competency should be measured coincident to the decision in question, not weeks or even months before the treatment is supposed to be administered. My preference is to allow emergency administration of treatment, which is subsequently subject to court review, would otherwise require a prior hearing. If incompetency is proven, then the court should decide what constitutes the least intrusive treatment decision most consistent with the ward's medical needs and previously indicated treatment preferences or lifestyle choices. This leads to the third part of my presentation, substitute consent for incompetent persons. Legally, after a person has been adjudicated incompetent to make a specific medical decision, the court should appoint a substitute consent giver to allow the patient to properly exercise his or her right of self-determination. Courts faced with the need for a substitute consent giver have three basic options. Allow the physician to make the treatment decisions by either accepting the medical decision without review or assigning the physician the responsibility of making the decision on the patient's behalf. Appoint an independent consent giver to act as a limited guardian or plenary guardian with the patient as the ward, or direct someone to represent the patient's interests, but set out in specific terms what those interests might be and how they should be measured. In each of these situations, the court requires the substitute consent giver to apply one of two leading assessment standards, the patient's point of view or the patient's best interest. The primary conflict in these treatment matters involves interrelated concerns. The theoretical nature of the decision-making at issue in often competing professional jurisdictions of doctors and lawyers. On the one hand, the judges who interpret and apply the law are unable to assess medical factors with the precision and accuracy of physicians. On the other hand, the medical decision-making best exercisable by physicians does not address the patient's non-medical interests, and in fact, may be inconsistent with other patients' interests such as self-determination. By training and experiences, judges are better able than our doctors to assess all the legally relevant non-medical factors, including the patient's preferences. Moreover, many judges are capable of assessing medical testimony to be utilized in a reasonable way by the trier of fact in arriving at a legal opinion. Finally, regardless of the perceived medical quality of the legal decision, each citizen has the right to judicial review before fundamental liberties are compromised. The solution to the problem of inconsistent judicial decision-making must be to improve the judicial process, not to eviscerate constitutional rights by allowing doctors to assume judicial duties. The law in recent years has endorsed the due process perspective by eliminating the alternative in which the physician makes the treatment decisions unilaterally without obtaining permission from a guardian or the courts. Similarly, courts generally do not give the treating physician the authority to make the decision on the patient's behalf, unless that authority is accompanied by specific limits on the doctor's discretion. By and large, courts now demand legal proceedings in which either some kind of guardian is appointed to represent the patient's interests, or the court itself determines what those interests are. There's one important exception to the right of judicial review, and that, as I have already mentioned, occurs when a medical emergency exists, in which the legal process may be too cumbersome to deal with immediate health needs of the patient. The recurring area of conflict is the applicable definition of emergency and whether it should emphasize a broad, medically oriented standard or a more narrow due process standard. The law appears to be moving towards a compromise between competing positions, neither allowing medical action whenever the patient's health is at risk, nor requiring a showing of immediate and substantial threat of death to justify any unilateral actions. One reasonable compromise found in the Rogers case in Massachusetts is to allow intervention only where to do nothing, in all likelihood, would make the patient's long-term prognosis substantially worse. If continued treatment is required, then as soon as is practical, a substitute consent giver should be appointed by a court. Regardless who becomes authorized to make the treatment decision for the patient, there must be a standard used to assess what should be done. The traditional best interest standard, which in recent years has lost favor, attempts to measure the community's response if collectively its members were in the same situation as the patient. The predominant standard today is called substituted consent and attempts to measure the patient's response to the treatment issue by ascertaining the decision the patient would make if competent to do so. To a significant extent, both standards are legal fictions based on subjective judgments of what either the community or the patient would do in a particular situation. Yet, if self-determination is to be meaningfully applied, then substituted consent is the standard that should be used. Before I attempt to apply the law of informed consent, ECT, I need to make two general observations. First, whether real or imagined, most Americans and therefore many mental patients have extremely negative images about the after effects and efficacy of ECT. The public holds images that are more consistent with what used to happen than what occurs today. Nevertheless, the past misuse of ECT, along with continuing horror stories about other kinds of psychiatric abuses, particularly in our public institutions, has poisoned the therapeutic environment, creating an atmosphere of distrust between institutionalized patients and psychiatrists. Second, without presuming to provide the panel with an overview of the medical literature, I will note that while the efficacy of ECT in the treatment of specific types of severe mental illness has been demonstrated, at least to my satisfaction, the issue of side effects is more problematical. Not only are there infrequent instances of bone fractures and temporary memory loss to contend with, but more importantly, in my opinion, is what we do not know. Our knowledge about the brain is at best incomplete, and we do not seem to be the tools necessary to measure the effects of ECT. Patients make claims about significant problems they have experienced, but beyond making conjectures in response, no one has been able to satisfactorily prove or disprove the existence of many of these problems, nor explain why they are reported so frequently. From the legacy of past abuses, mistrust, and uncertainty, social policy issues regarding begin. Competent individuals, including mentally disabled persons who have not been adjudicated incompetent, are presumed to have all the rights and privileges of citizenship, including the constitutionally protected right to approve or decline medical care, including ECT. Even though courts have made an exception to the right to refuse treatment in those life-threatening situations in which court authorization could not be obtained in time to help the patient, the exception does not apply unless the individual is unable to make a competent decision. At the same time, the law is equally clear that statutes and regulations that prohibit in absolute terms the use of ECT and other medically recognized and accepted treatments or unnecessarily infringe upon the privacy interests of patients who wish to avail themselves of such treatment alternatives are unconstitutional. The right to refuse or accept ECT becomes far more complicated when the competency of the patient is in question. The legal standard for competency has been noted previously differs among jurisdictions. Assuming that the threshold issue is settled and the patient is incompetent, then the doctrine of substitute judgment must be applied to ECT. In many regards, the application of the doctrine to ECT is similar to its application to other forms of psychiatric treatment. One difference is the perception that ECT is an especially intrusive form of treatment. Thus, before an incompetent patient can be given ECT, some courts have required that less intrusive treatments be used. Since what is less or more intrusive is at least partially dependent on subjective values, the more ECT is viewed as intrusive, the less likely courts will be to order its use. A second possible difference is the fact that ECT is normally administered as part of a series of treatments. If the patient becomes competent before the series is completed, then the patient would have the right to decline the rest of the series. What is unclear is the converse, a competent patient becoming incompetent in the middle of the series. In the event of an emergency, a physician may override the objections of an incompetent patient, but it is incumbent on the doctor to be able to show afterwards that an actual emergency existed and a legal representative of the patient could not be contacted. By and large, the legislative solutions that affect ECT use are not inconsistent with the case law. Most states have statutes that either regulate ECT specifically or regulate a broader set of psychiatric or medical treatments that include ECT. Typically, the governing legislation either provides the right to refuse certain types of treatments or mandates informed consent. Several states have schemes that seem to preclude using ECT without consent even in life-threatening emergencies. Most jurisdictions, however, either provide specific exceptions to informed consent in an emergency or more frequently are governed by common law principles and constitutional parameters. which collectively indicate that in an emergency, appropriate treatment may be administered voluntarily. One municipal ordinance passed in Berkeley, California, attempted to place an absolute ban on the use of ECT. Beyond creating quite a stir in the media, its effects were short-lived because the ban was held unconstitutional by a state court. In conclusion, with few exceptions, the modern law governing ECT is unwavering on 2 points. First, ECT cannot be absolutely prohibited by statute or regulation, nor administered without adhering to the requirements of voluntary, knowing and competent consent. Second, in the absence of an incompetency adjudication or an emergency, patients have the absolute right to accept or decline ECT, and where incompetency has been determined, the right for a substitute consent giver to exercise their right to accept or decline such treatment. In a democracy, this is as it should be. Thank you.
One shock treatment can equal 150 joules of energy. This is equal to dropping a hammer on someone's head from higher than a 5-story building.
At the FDA hearings, the testimony on the reclassification of electroconvulsive devices cited the literature as whether signed or false, typically about 150 joules of energy in a treatment. With the new Thymatron electroconvulsive device, if you check out at 400 volts maximum of 0.9 amps and 320-some millisecond pulses.
Could you finish up your question, your remarks?
Yeah, I would like somebody to tell me. I'm a teacher as well as a physicist, and I brought a kilogram with me. Teachers like to demonstrate. Now, this is a kilogram. It's 2.2 pounds. Heavier than a hammer I used to hit an amp. That I wonder if possibly like Dr. Stein could tell me how high I would have to drop this kilogram from in order to have it hit the ground with 150 joules of energy.
I don't know if that question is in the purview of the panel, but thank you for your report. I'd like to go on to the next person.
This is only 10 joules of energy. You're talking about dropping it from higher than a 5-story building. That's physics. Supposedly in pre-med backgrounds.
Thank you.
I never got
All right, out with your gun. Out with your gun.
Okay, this won't hurt. It'll be over in just a moment. What's that?
Conductant.
Oh, that will do you. Right, Mr. Jackson?
Open your mouth.
What's that?
This will keep you from biting your tongue.
Well,
Now just bite down on it.
oh,
That's right. Just bite down. Now bite down on it.
good. Are you ready? Here we go.